Ultimately, for me, the fact that we have sought this advisory will enable us to establish, indeed, whether this is a repeal or an amendment process, what is a basic structure, what constitutes an amendment versus a repeal. But ultimately, for me, you cannot use the very same instrument that empowers we, the people, to ultimately undermine the same constitution that protects we, the people, from said undermining. In other words, to use the Constitution of Kenya 2010 to begin to say we have, as the people, an opportunity to change this and that and this and that and the other, and ultimately end up with a document that erodes the same gains that are protected and enshrined in Constitution of Kenya 2010. That is my issue. But we leave the courts to decide this, Ben, or else we will be forever going back and forth. But I want to touch on something. Often we are told, as those who are part of the No campaign, and Linda Katiba, we're a few people, but there are very, very many Kenyans, whether they subscribe to the Linda Katiba platform or not, who have reservations and objections to this whole BBI process. But I want to underscore that it is those that brought forward the BBI that have the burden of proof to explain to us why they think we need to go this way. And the rebuttals that I often receive saying, what is your alternative? My alternative is implement the Constitution of Kenya 2010. And what we are facing today is impunity and disobedience to the Constitution of Kenya, the rule of law, by those who are in power. And I do not see how BBI in any way, shape or form is going to enhance a respect and a protection of the Constitution. We have added things, we have expanded the executive, we have expanded the parliament, and we are eroding the independence